The former vice president is regarded as an important witness because the former president pressured him to vote against Biden in the Electoral College. A federal judge presiding over Donald Trump's civil battery and defamation trial has denied the former president's motion for a mistrial. The same appeals court has denied Donald Trump's emergency motion to block Mike Pence from testifying in a criminal investigation. The sealed ruling by the U.S. Appeals Court for the D.C. Circuit the other day marks the end of Trump's efforts to keep Pence from divulging information to federal prosecutors unless his legal team takes the unlikely step of challenging the decision before the full D.C. Circuit or the Supreme Court. In today's video, we'll see how Trump was instantly hit by karma for his bogus acts. Let's begin. The decision came as E. Jean Carroll, the columnist who sued Trump, faced cross-examination in a session that included questions about a Law & Order SVU episode and Trump's former show, The Apprentice. Judge Lewis Kaplan, Trump claimed, had made pervasive, unfair and prejudicial rulings against him. His attorney, Joe Tacopina, said in a letter filed overnight Monday that he would instead ask Kaplan to correct the record for each and every instance in which the court has mischaracterized the facts of the case to the jury, or give him more leeway in cross-examining Carroll. Take a look at what the jury had to say, quoting from the juror's letter. Here, despite the fact that the trial testimony has only been underway for 2 days, the proceedings are already replete with numerous examples of defendants' unfair treatment by the court, most of which has been witnessed by the jury, the letter stated. Carroll sued Trump, claiming he raped her in the Bergdorf Goodman department store in the mid-1990s, and then defamed her by denying her claim, saying she wasn't his type, and suggesting she made up the story to boost book sales. Trump has repeatedly denied any wrongdoing. Tacopina raised several issues, including the judge's ruling barring Tacopina from asking Carroll additional questions about any efforts Carroll made to obtain security camera footage from the department store, expressing a corroborative view that no one was on the 6th floor of the department store at the time of the alleged assault, and labeling certain lines of the defense attorney's questioning as argumentative in front of the jury. It would be unusual for a judge to declare a mistrial based on his own statements made during the course of the trial. Tacopina attempted to imply that Carroll was not scared by the alleged assault during cross-examination on Monday. Carroll testified that she continued to shop at Bergdorf Goodman, and Trump's lawyer produced receipts showing that Carroll spent more than $13,000 at the department store between 2001 and 2018. I made it abundantly clear that Bergdorf's is not a place I'm afraid to enter, Carroll testified. She also admitted to being a fan of Trump's The Apprentice and enjoyed watching the competition between aspiring business people. Tacopina showed her a post from August 6, 2012 on her Facebook page in which Carroll wrote, "Would you have sex with Donald Trump for $17,000? Even if you could A, give the money to charity, B, close your eyes, and he's not allowed to speak?" When Tacopina asked Carroll if she ever joked about having sex with Donald Trump for money in a certain Facebook post, she responded in the affirmative and said that yes, she did. Trump's lawyer also looked over a series of columns Carroll wrote advising her readers to report sexual abuse and other harassment to the police. Carroll acknowledged her advice to readers to report allegations of rape to the police and explained why she did not do so herself. Carroll mentioned that she would never have called the police for something she was ashamed of. She consequently admitted that she was in fact ashamed of what had happened and thought it was her fault. While she continued to blame herself, she also reiterated how she could never have run to the cops. Tacopina also read excerpts from Carroll's book and questioned her decision not to sue former CBS executive Les Moonves after he denied sexually assaulting her in a lift. To which she befittingly replied, and here is what she said. "He didn't call me names," Carroll said. "He didn't grind my face through the mud like Donald Trump did." Tacopina also asked Carroll on Monday if she was aware of a 2012 Law & Order SVU episode in which a woman is raped in a Bergdorf Goodman lingerie department dressing room. Carol stated she is aware of the episode's existence and found the similarities to her own allegations astonishing, but she has never watched it. She stated that she does not watch Law & Order SVU because it is too violent for her. The jury saw an email sent by a stranger to Carol days after she came forward in 2019, describing the incident. Carol responded to the email at the time, thanking the woman for her email, but denying knowledge of the incident. Carol had shared her point of view in an email from months ago, and here is how it went. Also, there are 200 scripted shows a year on TV. This kind of thing is bound to show up. Indeed, I'm surprised this sort of plot is not seen more often, Carol had also written in the email. During the redirect, Carol's attorney, Michael Ferrara, questioned her about her knowledge of the episode. Ferrara inquired if she had seen the episode. Never, Carol said emphatically. He also asked if she knew what happened in the episode or if she had seen or heard of it before writing her book. Carol declined once more. Finally, the lawyer inquired, "Are you fabricating your accusation based on what happened in a popular television show?" Carol laughed again and said no. And that brings us to the end of the video, and we hope you enjoyed it. If you did, don't forget to hit the like button and subscribe for more.